first speech in New Zealand. Now, it's the 50th anniversary of the Roe v. Wade decision, which protected abortion rights in the US until it was overturned by the Conservative-dominated Supreme Court last year. It was originally the case brought by a 25-year-old single woman, Norma McCorvey, using the pseudonym Jane Roe, and the case was defended by the lawyer Henry Wade. Let's talk to Richard Johnson, Senior Lecturer in US Politics and Policy at Queen Mary University of London. Good morning to you. This was such a landmark in both at the point when it was first ruled and in what happened last year. Can you explain why it's so important?
Yeah, this is probably one of the most famous Supreme Court cases in US history. You have to remember that in the early 1970s, the vast majority of US states, about 45 US states, didn't make elective abortion a legal possibility for women. So this case was not just about overturning a small handful of states that continued to ban abortion. This fundamentally changed access to abortion for American women in the early 1970s.
And we have this situation from last year, which has changed that legal position. It's not quite as clear as saying that it's now illegal everywhere, is it? It's just all to do with the way the American states actually govern themselves.
Yeah, so the legal reasoning it's a little complicated, but I think it's worth just quickly outlining. So in the Constitution, in the 14th Amendment, which was passed after the Civil War, it says that no state shall deprive a person of life, liberty, or property without due process of law. But the question is, what is liberty? And there are some parts of the Constitution where the Constitution spells out what are individual rights, the right, freedom of speech or religion, association, the right to bear arms, freedom from cruel and unusual punishment, etc. But there's also an amendment called the Ninth Amendment, which says that this is not an exhaustive list of amendments and that there are other rights that are retained by the people. But the Constitution doesn't spell out what those rights are. And so what that has meant is that it's for the Supreme Court to determine what constitute fundamental rights. And in the early 1970s, the Supreme Court was building off of precedent, which had said that there is a fundamental right to privacy over intimate matters, including pregnancy. And that was based on a case over contraception in the 1960s, which said that you have the right to decide to have sex and to prevent pregnancy from happening. And so the Supreme Court, in a sense, was building off of that case called Griswold versus Connecticut in 1965 in Roe by saying if you have a right to prevent pregnancy from happening, you also have a right to terminate pregnancy.
So where does this leave women in the States now?
So what happened in the Dobbs decision in June was the Supreme Court said there is no fundamental right to terminate a pregnancy. And so what that means is that states now have the capacity to deprive women of that liberty because that's not considered to be protected by the federal constitution. In some states, elective abortion will remain perfectly legal, and there will be no change as a result of the Dobbs decision. But in nearly half of states, there have been attempts or successful moves to severely limit elective abortion or to ban it entirely. And so what we're going to see now is a patchwork where in some states abortion will remain as it has been for the last 50 years, and in many other states, it being very difficult for women to access abortion, if not illegal for them to access elective abortion in those states.
Richard, thank you for trying to explain some of that to us, as you say, complicated in terms of what it represents and in terms of the whole legal situation there. Richard Johnson, Senior Lecturer in US Politics and Policy at Queen Mary University of London.
LBC News.